headed to the People's Law School. It's at the Peachtree Library. So where am I going? Guess I'm going this way.
Grace, thank you for finding those. Give her a big round of applause. Good job, all right. So Chris is
freshman in college now, and then I got a freshman at Starr's Mill.
There it is. All right, my sister teaches at Starr's Mill, and I told him that if his freshman has my sister Whitney Shoemaker, then I apologize in advance. She's a very difficult teacher, but she's very good. All right, so ladies and gentlemen, without further ado, a big round of applause for Chris Piper.
Well, afternoon or good evening, folks. What a great program. This really is awesome. I'm thrilled to be here. Really happy to be talking to you guys about something that I'm obviously very passionate about. This is what I do for a living. Labor and employment is, broadly speaking, it's the legal framework that governs the relationship between employers and employees. So, a few ground rules for what I'm going to talk about here. I'm going to give you guys, the 50,000 foot view, right? We could probably, just this topic alone, we could spend probably a year in here talking about it, breaking down each law and different things that are happening in the courts. But I'm going to give you the big overview, talk about some of the things that I think are pretty important, and then I'm going to try to work in the things that a typical labor and employment lawyer does on a day-to-day basis, right? If you walk away with a couple of those things, we'll call it a win. The other thing that I want to tell you about, and I want you to keep in mind, I thought of a theme, for what we're doing here tonight. When I was talking, I'm one of those people that I believe in, try to break things down, keep it as simple as possible, boil it down to its lowest common denominator. And when I was putting the slides together and going through the information, right, I was thinking about my daughter. My daughter's in 9th grade at Starr's Mill now, but I was thinking about something that happened with my daughter when she was 5 years old. She got an older brother. We gave him both cookies, right? And my daughter, at 5 years old, noticed that Jack's cookie was probably about half a millimeter bigger in diameter. So, anybody got any ideas? I could see the light bulb. I could see the light bulb go off over her head. Any ideas on what she said? Anybody?
It's not fair.
That's not fair. That's not fair, for God's sakes. Exactly. How's this cookie bigger than mine? It's not fair. Fairness, right? Fairness. So when we're talking about the different concepts tonight, and we're talking about, you're going to hear it again and again. Fairness, a level playing field, right? That's a lot of what labor and employment law is about. It's keeping the playing field level. And we'll talk about some of the reasons that the law developed that way, the reasons they exist. But that's really what it comes down to. And I want you guys to keep going back to that as we talk about these things. It's just the basic concept, something you learn when you're about 5 years old. Is this fair? Okay, so with that, let's get going on it. So, why do we care? What does it matter? So let me get a show of hands here. So has anyone ever, rendered services in exchange for money? Anyone? Anybody gotten a W-2 before? W-2 before? Has anybody own a company? Any company owners? Who are my owners here? Oh, okay. Been responsible for payroll? Okay. So, right, they're alone, right? That's the employer-employee relationship. I think the other thing to think about is, where do we spend a lot of time? Right? Ideally, we'd love to spend more time with our significant others, with our children, with our friends. But as a general rule, for most of our adult life, we spend anywhere from 40, and if you're preparing for trial, you maybe spend a little more than 40 hours a week, right? But 40 hours and 100 hours a week, whatever, you spend a lot of time in the workplace, right? So those are good reasons to understand, what the legal framework is, what governs the rights and responsibilities of, if you're getting a W-2 or if you're the person issuing the W-2, right? What governs those rights and responsibilities? All right, so people use the term labor employment. I mean, a lot of lawyers, they take the ampersand out of it. It's just labor employment, right? It's really two distinct bodies of law, but they're interrelated, they're connected. And there's people like me, I do both. We're gonna talk about what the difference, and some people do both. Some people specialize in one or the other, which we'll talk a little bit about. But labor is one thing and employment is one thing, and they both kind of developed on separate tracks, but they kind of come back together every now and then. Separate tracks, they come back together every now and then. All right, so traditional labor. Anyone ever been in a union before? Okay. Maybe relatives in unions, anything like that, familiarization with unions? Okay. So you heard from Judge's introduction, my bio. I'm a management side attorney, right? I represent companies, okay? And I have been, that goes back pretty much, I've been practicing law for 20 years. Always been on the management side of things. What I'm gonna say is maybe gonna surprise you a little bit. I'm not against unions, right? I don't have a problem with unions. What I have a problem with is the things that companies do to their employees to get unions, right? To get unionized. That's where my issues come in, and that's a lot of what my role is sometimes, is trying to help companies do things, right, to keep unions out. You don't need a union necessarily if you want to have a direct relationship with your employees. So, how did these things come about? So, I'll give you a good story here. So my wife is from Wilkes-Barre, Pennsylvania. Anybody familiar with that area? All right. Coal country, right? That's where the coal mines. So we go up there, go visit the in-laws. One day we went and there's a thing called the Lackawanna coal mine tour. So if you're ever in Wilkes-Barre and Scranton area, I highly recommend the Lackawanna coal mine tour. It's pretty cool. It's a coal mine that shut down in the 60s, and they take you out there and you get in a cart, you drive down in there, it's really neat. But before you go in, right, they show you this film. They put everybody in this room and they put a film on. And they talk about what industrial life in a coal mine was like at the turn of the century. Bless you. Look, I'll be blunt with you, it sucked a lot, okay? It was bad. It was dangerous. It was dark down there, people got killed, you got these coal carts rolling around, they weighed tons because they got all the coal in them, people losing limbs, and they're showing this film and they're talking about all this, and they get to a point and they're, hey, somebody gets killed and the company would come to the house because you're living in basically base housing, right? And they would ask the person at the house, and say, hey, your husband died. They're talking to the spouse. You need to pick up all your stuff and hit the road, right? Unless, hey, do you have a male who can go down and work in the mine, right? Maybe we'll let you say. I mean, bad stuff, right? This is all horrible. So, at that point, we're watching this film, and I lean over to my wife and I said, should I give the management perspective? And she moves away a little bit. And I mean, there are people turning around and looking at me, death stares, right? This is horrible. I tell you this story just to make the point, right? That things were going on in the workplace, right? Where, left to their own devices, like the coal barons feel like, they're gonna do everything they can to squeeze every ounce of money out of those companies, right? So employees said, hey, we need some strength in numbers, we need to get together, we can collectively work together, right? It's better to work together than to work separately. And that's where unions formed, right, over time. Probably a little bit before that, that's just one example, but unions came into vogue because that's something that they needed, that employees needed, just to protect themselves and to gain some rights and that were needed in the workplace. So again, I have no problems with unions. Again, my problems are just what people do or what companies do to get unionized. Nothing as horrible as that, but companies nowadays still do things that that really aren't in their best interest. So let's talk about sort of the law, primary areas of practice, things like that. This is a very busy slide, but I'm going to try to work things together and show you how they're interconnected. So let's start a little bit with the law. So the major law, like the big daddy of all these things, is the National Labor Relations Act. Okay, so this is the law that governs unions and unionization for the vast majority of private employers in the country, right? Private employers. Okay. So it gives employees the right to organize, right? They can voluntarily organize. They can elect a bargaining representative, somebody to speak on their behalf. They can engage in collective bargaining, right? They can get together, they can work out a contract, right, that governs their pay, their work rules, their benefits, the conduct of the workplace. And they can protest. They can go out on strike, right? They can use economic powers at their disposal, right? Without any kind of recourse against them. They can go out on strike to put the company in a little bit of pain to try to get their rights. So that's the NLRA, right? And the administrative, I've got in the brackets there, the NLRB, the board. That's the administrative agency that basically administers the NLRA. So I said the vast majority of private companies, right? So its cousin there is the Railway Labor Act, right? So the Railway Labor Act covers airlines and railroads, okay? So private employers, but a carve out for airlines and railroads. So anybody got any idea why we would want to have a separate labor law for unions, unionization, things like that, just for airlines and railroads?
Because they're interstate?
Yeah, interstate, but it has to do with commerce, right? So RLA came in the 1920s, right? Railroads were the country, right? Everything ran on railroads, shipping, goods, things like that. Airlines came in the 30s, they incorporated in the RLA. The difference between the two statutes, there's a lot of minor differences, but the one big one is that it is much harder to get to an economic incident, a strike, in the railroads and the airlines than it is for pretty much everybody else, right? And the reason we do that is that it would have a significant impact on the national order, right? The national good, commerce, goods and commerce maybe. Think about it right now. You think about the airlines, right, and where we're at. There's really, there's 4 really big airlines, or really 3 if you want to be completely candid. If one of the 3 went on strike, that's 1/3, basically. That's 1/3 of air traffic in the United States. What would that do to us, right? That would hurt a lot. So they make it hard, and there's different trade-offs, right? The RLA is more encouraging to finding agreements. It drags things out. That's the NMB's function. That's the administrative agency that oversees the Railway Labor Act. But they both get to the same place. They're giving employees, right, the ability to get together collectively and have their say. Now, the other thing these things do, right, is they give the employees the right to not do this, right? You don't have to organize. You don't have to get together. You can ignore that. The union comes out and says, hey, do you guys want to have a union? You can say no, and we'll get to that in a little bit. Other statutes, the Federal Service Labor Management Relations Statute, that's for federal employees. I'll level with you, I don't know a ton about it. I've never really done any work in that space, but if you're a federal employee, you can organize. And they make that, it's kind of this sort of watered down union environment. You can't really go out on strike. You got a lot of things that, but you can do it. And then I've got state law up there with a question mark, right? State law doesn't really come into play just for sort of, governing unionization and rules about unionizing. It's a thing called preemption, right? The federal laws kind of take over, although there is a case right now bouncing around in New York where the New York board stepped in and did something that normally the board, the NLRB, does, and they're fighting it out in court right now to see if that's good. They're not going to win, but that's just the way it is. Mostly with state law, you'll see things like maybe right to work laws. Have you guys heard of that? What a right to work law is? I was just up in Pennsylvania doing some work up there, and they do not, there's not a right to work state. So what that means is that if you're in a union, right, you can get a provision in a contract that says if you want to be employed as a condition of your employment, you have to be part of the union, right? You get out of the union, they can fire you. They call it, there's a dues check off. They can just take your dues right out of your paycheck. So Georgia's not a right to work state, but a lot of states are. So they'll come into play there. And then obviously you just got to understand state laws because, we'll talk about with bargaining, you can't, there's some things you can and can't do, you gotta follow the law. So speaking of bargaining, part of their primary areas of practice, these are really the three that I came up with. This is what somebody that practices in the traditional labor space, a labor relations lawyer, that's what they're also, these are the three primary things that you do, right? So the first one is union campaigns, right? We're talking about, you've got this statute, it gives you a right, you can go do this. Well, let's say you're a company, right? And you got the union out there and it's, soliciting employees. Well, again, I told you, they don't have to do it. And the employer, you're allowed to give your side of things, right? Now, you can't do things, you can't coerce people. Like you can't go and say, hey, if you vote no on this union, right, then I'll give you this, right? You can't do anything like that. You can't say, hey, the company's gonna shut down. You can't threaten people. But you can give your say on things. You can talk about, what you do and why you think it's better to not have a union, things like that. And it's a campaign, right? That's how unions get into companies, right? It's a very democratic process, right? Remember what we talked about, fairness, right? It's fair, you vote on it, right? So the way it works is the union will come in and they'll get a showing of interest, and then they'll go to the board and say, look, we've shown that 30% of the employees of this company would like for us to have an election. And then you go and you have a secret ballot election, right? And they vote on it, and the employees vote. It's up to them, right? But before you do that, you go through a campaign and you have this sort of, again, this democratically elected, right? Union can come in, or they can get voted out, right? So that's something that, lawyers are all over that process, right? We talk about how it works, and then, we're there at the beginning of it a lot of times. You're either, representing the union and giving them advice on the things they can and can't do as far as talking to employees and how they can do it. If you're on the management side, you're maybe talking to managers and training them and helping you how to give presentations and how to talk to people about this kind of stuff and the things that you can't do. Like I mentioned, right? You can't threaten people, you can't coerce people, you can't make promises, things like that. You got to let the process play out while at the same time giving your side of things. So that's a big thing. Let's say you get a union, right? You have a union. Collective bargaining, right? That's another thing that labor lawyers do a lot of. Judge mentioned Delta. I spent a lot of time at Delta negotiating contracts with unions, right? Delta's unique in the airline industry. It's only got a couple of unions, right? That other thing up there, union campaigns, like those have been going on at Delta for a long time. Did some of that work as well. But once you have a union, you got to sit down and you got to bargain, right? And again, that's where you sit there and you talk about it. Okay, I can give you this much money, and you get this kind of work rule. We're going to do this with your schedules. We're going to do this with your benefits, right? And you sit there and you negotiate. So it goes a lot of strategy, a lot of thinking about, how are we going to do this? What kind of offers are we going to make? How are we going to position ourselves? A lot goes into that. So lawyers will, you can be the spokesperson where you're sitting there at the table and you're speaking on behalf of the company. Done that. You can be in the background, where you're giving advice or giving legal advice a lot of times. Remember we talked about laws, state laws? Hey, somebody from the management side comes and says, hey, I've got a great idea in bargaining. Let's go and say, you're going to work, I don't know, 80 hours a week, but we're not going to give you overtime. So, something crazy like that, right? A lot of you, we're going to push it right up to the line. Let's see how close we can get to actually, getting to the law without violating the law. So they'll come up with all kinds of ideas where you need a lawyer in the background, checking this and saying, hey, how do we feel about this? What kind of position is this going to put us in? You need to be able to kind of look around corners and say, down the line, this is going to play out in such a way that this could put us in some legal jeopardy, and we don't want to go there. So a lot of that kind of work with collective bargaining. And then the last thing is, grievance arbitration. A lot of labor lawyers, people like me, go and do arbitrations, right? We're trying cases. And it's everything from, silly stuff like, somebody looked at me the wrong way to, big time contract cases. We did one a few years ago, which we valued at close to $900 million, right? A lot of money floating around this stuff. So it varies, but, that's a lot of work. And you get unions and they got their lawyers, right? They're going to want to go and they're going to want to, file grievances, and they're going to want to take those to a neutral party. It's not a judge. A lot of times it's private arbitrations most of the time in these cases. But they want to have their say, right? They want a right to be heard, right? See, what are we getting to, right? Fairness, basic fairness, right? I've got a complaint. I want to be heard. I want to have a neutral make a decision on whether or not what I'm saying is valid or not. Okay? So do a lot of that work. And then these other things up here, unfair labor practice claims, right? So that's stuff like, you know, you're in a union campaign, right? And somebody does make a threat, and the union, you know, says, hey, wait a minute, it's an unfair labor practice. You just violated the NLRA. Well, then you can go try that case in front of an administrative law judge, right? And you can reach a result, or you know, you failure to bargain in good faith. Stuff like that comes up all the time, and you go, and again, you put your case on, and you reach a result. Administrative law, that's practicing in front of the boards. Litigation, right? It's spin off into court cases, right? I mentioned that state case up in New York, right, where they're challenging whether or not, you know, the NLRB actually has, you know, jurisdiction over a case because it gets crazy because they don't have a quorum. But a lot of these cases, you know, a lot of these ULP cases will get appealed and they'll end up in court, and then you're arguing in front of a circuit court about, you know, whether you're right or wrong. But all of these other things are just kind of spin off out of these big three. And you could be doing any one of these things any day. You could be doing a couple of them, 2 or 3 of them a day. You could be training, you could be conducting an investigation. You could just be giving advice and counsel, interpreting the contract that you negotiated or somebody else negotiated. Just helping your client understand what their rights and obligations are. Okay? Let's move on. So next part of it, right, we talked about labor law. Now let's talk a little bit about employment law. So, just make sure we're covering everything here. Now, employment law is, you know, again, the relationship between the employer and the employee, regardless of union status, right? So it doesn't matter if you're in a union or not. Employment law is going to apply, right? So in other words, just because you have a union and you have a collective bargaining agreement, there's a saying, right? You can't contract around the law. Like I can't make an agreement that says I'm going to allow discrimination, right? Or I'm going to allow, you know, some violation of wage hour laws, things like that. The law is always in place, and you always got to follow the law, regardless of whether you're unionized or not. Now, again, the goal here, you know, this is a sampling, but employment law is really just an alphabet soup of statutes, right? It's just a group of rules and laws that come from every which way. This is just, again, these are the ones that just off the top of my head, and these are things that I've dealt with just in the past probably 5 months or so, 6 months. But we could go on for pages, right? There's law after law after law. The big ones, right, these are the federal law. When I first started practicing, probably again 20 years ago, federal law really dominated. But as time has gone on, the states have started to make more and more what I would call substantive employment laws, right? They're filling gaps that maybe the federal laws don't fill. So for example, you may have a federal law, federal discrimination law says you can't discriminate, but there's a number of employees are required, right? You have to have 25 employees for that law to apply to you. Well, state law may have no rules about that. You can have 0, you have 1, have 1 employee, 2 employees, and that law is still going to apply. So a lot of times, if you get sued, like when the companies that I represent, when they get sued, it's usually under some sort of federal law as well as a state law that they pull. Some of the state laws are just more favorable, right? Wage and hour laws are typically, depending on the state, you may find more favorable wage and hour laws than the Federal Labor Standards Act. So they're both, you have to be accountable for both of them, more so now than ever before. The state laws are changing rapidly. That is something that we've seen go on. I guess that's a relatively recent development, but state laws have been changing a lot. They're becoming, again, more and more, more and more employee friendly, right? So you just have to be aware of them and be able to account for them. Just a quick rundown of a few of these, right? So Title VII of the Civil Rights Act, right? So Title VII, that's discrimination, right? Can't discriminate against somebody for, their race, sex, national origin. Can't treat people differently for things that, are completely out of their control. Can't harass people. The same things, right? Can't harass somebody based on race or sex, national origin, things like that. What does that sound like, right? It's fair. Right? Basic fairness, right? We always come back to basic fairness. Family Medical Leave Act, right? You got a serious medical condition, right? Well, you're allowed to go on leave from the workplace, right? Bonding, baby bonding, right? That's a new one that kind of got incorporated into the FMLA. If you want to bond with your child, that's something, again, it's kind of, the generations are changing, right? The laws are changing and evolving. My dad was 90 years old when he passed away. And I remember, I didn't really talk to him a lot about what I was working on, but at one point when I was at Delta, I was working on a paternity leave provision for the contract that we were in. And I told him, I said, yeah, it's, if you have a child, you can go and, within 12 months of the birth of the child, you can go and you can spend a certain amount of time bonding with the child. And, he just kind of looked at me and why would you want to do that? Okay. But, other people see it a little bit differently, right? It's a good thing. But, always changing, USERRA, right? Military leave, right? If you go on military leave, you're not going to be penalized for going and serving your country, right? It's basic things that, again, that was a kind of reaction to the Gulf War, right? Not the reason, but back in the early 90s, right? A lot of folks went away, they went to serve their country, they went off to war, came back and didn't have jobs, right? So Congress reacted, right? USERRA came into place. Again, basic fairness, right? Let's keep the playing field level. I put just a sampling of some of the state laws. In Georgia, if you have a sick plan, right? Well, somebody can go out sick, but they can also go out when they're not sick just to take care of a family member. We call that kin care. Washington, Minnesota, paid sick leave laws, right? They'll come out and say, not only can you got to have a sick plan, but you got to pay people while they're out. And then, some of these laws, if it's within 3 days, you can't ask them for a doctor's certificate. Things like that, right? Again, very employee friendly. States kind of jumping into the mix here, saying we're going to fill some gaps. We're going to, listen to our constituents, and we're going to come up with these employee friendly laws. And then, I've got something up here with California, just California in general. California is just a whole other thing. There's a whole industry of lawyers that do nothing but California law. Like here at my law firm, there's like a group. That's all they do, California law. And they'll represent, they'll talk to a lot of companies that may not be based in California, but you do work in California, you better have somebody that knows what they're doing in California, because the laws are very difficult, very employee friendly, and you can get in a lot of trouble, a lot of damages, a lot of money, right? If you don't do it the right way. So
you have to be licensed to practice in these issues in all these states?
Yeah, if so, it depends. Like if you're in California, it's a good idea to be practiced and be licensed in California to give advice on California law. But there are different provisions. Let's say that for whatever reason I wanted to go, I was going to go try a case in California. You can be admitted to that court for just very limited purposes to go try that case. I can tell you I would never in a million years find myself in California without dragging somebody that knew what they were doing. Because again, it really is, it's a kind of a different world. But it just goes to show, I just make the point that different states have these different laws, sort of this different patchwork, and you gotta be aware of them. If you're gonna do business in one of those states, it's gonna be different. If you're a Georgia company and you're doing business in Florida or South Carolina or California, your employees that are working in those state laws are going to apply to them, and you need to be cognizant of that and know what you're doing with it. And this is some of the stuff, again, this looks very similar to what labor lawyers are doing, right? Employment lawyers, if you're practicing on the employment side, you're doing a lot of the same stuff. Workplace policies, big on that, right? We're talking about all these different laws and different things that you got. Well, lawyers will do a lot of work to help write policies for different companies, right? Help you understand, the different potholes, the different things you can run into. Try to write good policies so your employees know what's going on, right? Big part of this, right? Big part of it is knowing what the rules are, right? So that way, if you end up breaking them, right, you can fairness, right? Let's be clear in what our policies are. Let's tell our employees what the expectations are. Let's tell them how to do these different things. Let's give them a process of how to complain. When they complain, let's go and let's follow our own procedures and do it correctly and make sure that they're fair and that they're, that we're doing things the right way. So it always comes back to that, right? All these things at some place where you're doing it, whether you're conducting an investigation or you're giving training about how to do things, or you're drafting a contract, or you're negotiating an agreement or something like that. All of these are skills that people that practice in the employment space need to have, right? They all come back to where we started. Let's think about what's fair, what's right, what's a good deal for everybody here. It's what lawyers, that's what you're doing, and that's what you get paid to do, is to make sure, again, you're doing it within the bounds of the law, but you're also finding out what's fair. So with that, in my time, I may be pushing it a little bit. You want to ask any questions, feel free, but I will stay around afterwards. I want to give John full time. I'm happy to hang out. I'll stand out in the parking lot and ask questions for you guys.
Bonnie, why don't you ask a question? We're going to get Anna Grace to set up our computer. And we'll go
Just
from there.
a very quick question, kind of related to what somebody else asked. If you've got companies that operate across state lines, a company that's in every state, they're not going to have 50 attorneys who specialize in the laws of each of the 50 states. How in the world is that managed?
Outside law firms. Seriously. I'll use my experience as an example. So I worked at Delta, right? In-house at Delta, I don't know, we probably had, and Delta's a huge company, right? So 100,000 employees worldwide. Probably anywhere from 50 to 75 lawyers at any one time on the payroll internally at Delta, right? Well, we didn't do all that work by ourselves. What we would do is go and get outside law firms to help us, right? So that's what I'm doing now, right? So an outside law firm comes in and, again, we had an issue out in California, right? We had a big problem out in California. We had law firms out in California that we would pay those lawyers to help us, and they would work with in-house counsel. So that's big companies. Smaller companies, it's the same basic premise, just on a little smaller scale. So there's always help. There's always lawyer to help you do something. There's plenty of lawyers. That's one thing we're not going to run out of, right? So you can always find somebody in some jurisdiction, whether it is. I went up to Canada. I was just going up to Canada and I negotiate contracts up there, and I learned the hard way. I went up to a mediation, and I remember thinking I'm sitting up to 1,000 mediations, the easiest thing in the world. I get up there, they started reeling off these Canadian Supreme Court cases. Yeah, okay. So you always want to, again, be cognizant of where you are, understand what your limitations are, but be able to find folks that understand the playing field that you're on and can operate.
Is it okay if I send your contact information out if they have follow-up questions? And is it okay if I send anybody who wants to see the PowerPoint? Can I do that?
Absolutely. And I got cards if anybody wants them.
Here,
And
let's
like I
pass
said,
them around.
I will hang out.
Okay.
I didn't bring a ton of them, but I'll leave them up here, and then I'll stay.
And what I'll do is we'll give them your information as well, so they don't get a card. Let me let you end with this because I want John to start with this. Can you tell us what an average week looks like for you in court versus out of court, in meetings versus not meeting, just a general week?
A general week, okay. A fair number of calls, conference calls, right? So Teams, right? Microsoft Teams, Zoom calls, things like that. I'm on with a lot of folks. I travel a fair amount. I get on the road. I'll give you an example. Last week I was up in Philadelphia, and it was a union campaign issue, right? So I spent the week up there. In between, I would get on calls and talk through different things. Had to review a few different documents, a contract to opine on it. Had to write basically sort of a pseudo memo in an email to give, here's what I think, we need to do here type of thing. And it just varies from place to place. As far as going to court, again, in the litigation world, and it's, every now and then you get one that's you're gonna go try it. Arbitration's a little different, right? Arbitration, 2 or 3 days, you're in and out. Maybe a little bit longer, you maybe have 5, 6. I did one arbitration, took us, a month to do it. But if you're in that, then pretty much everything goes into the trial, right? If you're trying something, everything's on that, everything else goes on hold. But yeah, it's pretty, you try to balance it as best you can.
Thank you, Chris. Big round of applause for Chris. after that, every week, we let everybody know what's going on at the courthouse. If they want to come by and watch a trial, watch a hearing, you want to see an argument, you want to see anything, all you got to do is just follow us on any of these social media sites, and you're going to see it every week. We try to post it as much as we can. So if anybody, whether it's you or you have a student that wants to come by and watch, they just want to come by and be a visitor and watch at the courthouse and just see what it's like, please let us know. I always tell the students when they go in, I go, it's not like Law & Order, it's not like CSI. I told Anna Grace it's not like Matlock, and then she asked me what a Matlock was. So anyway, if you follow us there, we'll make sure you get the court calendar. Now, I get to call up John. And here's the best part about doing this, is I get to pick the people that I want to work with. And I want to work with people like Chris and John, who are good lawyers, who are professional, respectful, and they know their stuff. And I like working with them. And I like working with both of these guys. And let me tell you about John, native Georgian, practiced law for 30 years, and he serves our community on the Zoning Board of Appeals. He started off, had a really hard job, public defender with the city of Atlanta, and he had to represent a lot of folks on a lot of things. Then he went to private practice, and he does civil work, and he does criminal cases. So he's going to talk to us today, and this is the first time anybody's ever talked about trial prep, because we see the cases in the movie all the time. We saw that, hey, Matlock was a lawyer, it was a TV show, Anna Grace, Andy Griffith. He also was an actor a long time ago. And he would go in there, can I borrow this, Mr. Michael? He would try a murder case, and he'd go in there with just his legal pad, and he'd do it in 42 minutes, and he didn't have any boxes or anything with him. That's not quite how it works, okay? Not at all. It doesn't move like that. So John's going to talk to you about trial prep, because there's a lot of work that goes on behind the scenes before we go to trial. So without further ado, Mr. John Tate, thank you very much.
First, thanks to Judge Thompson. I think he's doing great things all around Fayette County. And in case you didn't know it, if you've never been in his courtroom, he has great programs, especially for the younger people. When people get charged with like the misdemeanors, and they just kind of are in that stage where they're not really criminals, but they do criminal acts. So there are programs that he has set up so that these people can get their lives straightened back and then proceed on. And this is something you don't find everywhere. And I say that because, as he mentioned, I've been a defense lawyer. I'm really a trial lawyer. And I've done that for over 30 years. And of course, being with the public defender in Atlanta, everything came through there. So being in the courtroom is just kind of like second nature. Okay. The good thing about it is that, of course, even though we were in court 5 days a week, the good thing is that we only work like half a session. Either I work the morning session or I work the afternoon session. And I did that for about 15 years. Left there, and then I started my own practice. And of course, because I had done criminal law for so long, of course, naturally, I began doing that again. Because to me, criminal law has always been fascinating. You find so many variations of things that happen, and you're talking to people, and it's just, to me, there's always something different. You see some similarities. So I may say some things and talk about some things that you're already familiar with, but what I really want to talk about is just from the standpoint as a defense attorney. What do you do? I'm going to talk a little bit about the criminal side of it, and then I'll touch on some of the civil side. And one of the things for me that I've always enjoyed, because I like going into different courtrooms. I like working with the wood. I like to travel. So going into private practice has allowed me the opportunity to travel throughout Georgia, all over Fannin County, Cordele, Madison, Athens, Fort Valley, and if you like looking at like how structures have been well maintained and built up, if you're ever in Coweta County, go into the probate court in Noonan. Beautiful building. If you're ever in Madison, go to that court. Beautiful, beautiful wood. So this practice has allowed me to go into these places, and of course what happens when I go into these places, first thing I do is I want to see how is the judge handling cases? What kind of sentences is this judge giving out? So I usually, if I have a case in a courtroom, I'm gonna get there early so I can sit down and see, okay, how do I have to handle this? That's one of the things I liked when I first went into Judge Thompson's courtroom. I was very impressed with the manner in which he was handling his cases. But, and don't let me get off on, just some of my war stories. Anyway, what I want to let you know is that, of course, the process itself, whether civil or criminal, they're governed by the statutes. You might hear people say OCGA. That's the official code of Georgia. And of course, the official code of Georgia covers the processes, whether it's criminal procedure or whether it's civil practice. So, from the criminal side, let's just say the first thing that happens is, a client comes to you, they are either they're in jail, and the parents come to you and they say, okay, we want you to help our son, help our daughter. Well, sometimes the first thing you gotta do is try and get a bond for them, get a bond set up. And of course, so you go through the interview process. Then of course, you get your, let's just say the client comes in. So the first thing, of course, is the interview. And that's when you find out as much about the client, and then you get their side of what happened. How is it you got charged with this, okay? Right after that, of course, you go get a copy of the incident report. And you know what? It's surprising, but somehow those two things, it's like, oh, wow. But, so what you do is, of course, that's just the first stages. So, you go back and you talk to your client about some of the differences that are on the incident report as compared to their side of it, and of course, they're always right. The next step in that particular process, of course, is if it's a felony, then the district attorney is going to take it to the grand jury. Misdemeanors, the Solicitor General is going to do an accusation. Either way, what happens is after the police have charged the person, they may charge them with 8 counts of something. You take it to the grand jury, they may end up with 4. So, those 4 charges are really what you concentrate on. First of all, it's a matter of looking at the charges, because every charge has specific things that make it a valid charge. So you go through each particular charge, the incident, compare it to the statements, either from your client, from the police report, and then you start to develop at least some type of theory. Okay, well, how truthful is my client? How strong is the evidence? Do the facts fit all of the elements required for this particular crime? Aggravated assault, okay? It requires an intent. Crimes require an intent. So, if you don't see that, then maybe there's something that you can say, okay, well, maybe that's a chance we can get this person off on this, so we can get that charge reduced. Then, of course, after the indictment comes the arraignment, which is basically just a procedure. You go in, the client is always not guilty. But the good thing about after the arraignment is that the DA has to turn over the entire file. everything that they have inside that file, videos, photos, everything that they have available, they must turn it over to you. So from there, of course, and right now, of course, the files can be really humongous because they get all the police investigations. So that's really where a lot of time goes in the research. Not only are you looking to see, based upon the charges that the grand jury has presented, are the facts sufficient enough to believe that the client may have committed these charges, or are there parts of those charges where, you can find, a loophole, you can find something that doesn't fit. And of course, you are required to reciprocate with the DA. Any evidence you have, you gotta turn that over to them too. And so you go through this particular process, and that's where your research comes in, okay? Not only are you researching the statutes for the particular charges that your client is charged with, but then the next part of it is to try and develop a theory of a defense, which means, of course, you do your case law research. That means that you find cases, you go on certain sites like LexisNexis or whatever. Oh, one thing I wanted to say too, is just a little caveat. When you see things on TV and they say, don't try this at home. Okay. So, but you start doing your research and you try to find cases that are favorable to the situation that your client is involved in. And of course, what that means is that you have to put in a particular type of phrase to determine, for the case laws to come up. And of course, it may give you 20 cases. So you go through and you read each case to find out, is it gonna be favorable? Many times they're not, and if you don't find any there, then you continue to do a little bit more research, you find something there. And sometimes you don't find anything that helps you, okay? So, let's just suppose that's a situation where the evidence is just so overwhelming. I mean, there's just no way that you can find any legal defense for your client. Well, of course, the negotiations. That's where you try to find some weakness in the prosecution's case, and then you in the prosecution get into your own negotiations. And one thing about it, whatever the charge is, the prosecution will always make an offer. It might not be what you want to hear, but they're gonna make you an offer. And so that sometimes is a back and forth. Of course, certainly throughout this whole process, what you're doing is you're talking with your client, you're letting them know, okay, this is what we're up against. These are the offers that are being made by the prosecution. What do you want to do? And so what you do, or what I do, is to kind of just mention to them, okay, now, if you go to trial, this, and this may happen. You're not gonna have any say-so over the outcome. If you do a negotiation, then you do know up front what's gonna happen. And then, of course, sometimes it's a matter of, it's like a chess match, okay? Because prosecution is all the way up, through the pretrial conferences, and you get a chance to offer motions for hearings. You might want to say, well, look, I don't want this particular evidence submitted, so you filed a motion and the court has held a hearing and they found out, well, no, you don't have a valid basis for it. So you're up against the wall in that kind of situation. And then of course, what you do is you stay strong to final second. I've actually had a situation where we didn't make a decision until the day of court when we were inside the courtroom. Because one, the state really doesn't want to go to trial. You don't really want to go to trial, but you push it as far as you can. And sometimes it works out well, but you know, the other thing about it is that you have at least put all the effort. You've done the research. You can seriously tell your client, these are the facts, these are your options, and of course, the client always makes the final decision. My job is to advise them of the outcomes that could occur depending upon what decision they make, and then you go along with it. I'm looking at the time. As I mentioned, with regard to the trial of any particular case, whether it's criminal or civil, you know, the preparation, the processes are similar because, of course, the civil side of it means that these cases are governed by what is called the Civil Practice Act. And of course, under the Civil Practice Act, it means that there has to be certain things that are followed. Okay, that's got to be a proper service or process. If you've been served on the civil side, then of course, under the rules, you must respond within 30 days. If you fail to respond within 30 days, the other side has a right to go to the court and say, hey, I want a judgment by default. 30 days has passed, you don't respond, they have to wait an additional 15 days. If nothing happens in those 45 days, then that other party is going to go get a default judgment against you. So for whatever they have requested, it's going to be granted. Not to say that you can't open up a default judgment. Yeah, it's possible, but it's not easy. Okay? Because what the court looks at is, well, you had all this time to respond. You didn't do it. But either way, like I said, those are procedures that are governed by certain things. So what happens with the civil side is very similar to on the criminal side. Say the complaint has been answered, and so from that standpoint, it goes into what is called, again, the discovery period. That means that each side has the opportunity to request from the other side certain information. You have the right to request copies of documents. You have a right to require them to submit to depositions. You can present interrogatories, written statements you want them to answer, and they must respond. So both sides have the opportunity and have the right to send to the other side certain things. I want you to send me these documents, okay? And that's especially true, especially like, say, in divorce cases. You know, you're gonna have to submit your tax records, wage statements. Oh, you gotta submit everything, okay? And you must respond to the request. If one party fails to respond, then you file a motion with the court and say, Judge, I want you to compel these people to respond because we have submitted our request based upon what the statute says we can do. They haven't. Then the judge will issue an order for them to comply with your request. If they still don't reply, or respond. And you go back to the court and say, okay, they still haven't responded based upon your question. I want you to issue an order that's gonna put sanctions on them because they have failed to respond to a particular court order. And of course, that's also a process that can happen. And sometimes it does happen. But the point being is that everything that goes on from the standpoint of preparing for trial, you do your research. You got to search your cases. You got to accept the fact that whenever your client tells you something, there's always another side to it. And so you look at each side of it and you then try to determine, okay, what's the best way? What's the best approach? How can I best serve my client? And some of the things that, of course, when you go to court, what you find out is that most judges will tell you, if you go to trial, somebody's going home and they're not gonna be happy. So, negotiations, plea agreements, or just being able to reach a mutual agreement between the parties, whether civil or criminal, is generally the best way to assure that the outcome is going to be something that you can live with. So I see the time is getting a little short, and so I'm not going to just continue to ramble on with things, but it's a pleasure to be here, and certainly if there are any questions, I'll be happy to try and respond.
You might have a question for John, David, what you got?
I have one. Considering your criminal defense work, I recognize most of the adjudications are plea agreements and so forth. But in your 30 years, could you ballpark a percentage of people you believe that are actually innocent?
Next question.
In reality, I think that the system has been fair from the standpoint of if they were innocent, I've actually seen them receive proper adjudication. Just take that a step further. That was several years ago. I did a murder case. And all of the evidence pointed toward my client. The phone records, the cell phone placed her at the place of the incident. Following the taxi cab that came to get her. I mean, everything. But there were a lot of circumstances and she would never really divulge to me anything that might be helpful to her. And this is a situation where the prosecutor kept asking for life with chance of parole after 30 years, and we kept saying no. So the day of trial, we came to agreement, and she had already been in jail for 3 years. So we entered a plea to a 25-year sentence, which means, of course, she would get credit for the time, and she would get good time credit while she served. But it was overwhelming. But yeah, so most of the time, justice is fair.
I have a question real quick. Has anybody had jury duty? Okay. Has anybody made it into the jury room? So your wife actually had jury duty?
I me too. Yeah.
Okay, and it was what, a couple months ago that that happened?
My wife was a couple of months
Couple months ago?
Mine
Okay.
was a couple of years ago.
So, again, show of hands for those that went into the jury room and you actually had to deliver it. Jury duty is hard. The jury room is not too far from where I sit. And I hear, not what's going on inside, but I hear screaming. I hear singing. I hear laughing. I hear crying. I hear praying. Because jury that we have in the jury system, they really, really work. We're blessed in Fayette. Juries really work. And I have a chance to talk to them afterwards, and I say, well, how was it? And they're like, this was tough. It's not what we thought it was going to be like in the movies, and we really work because you get like a cross-section of people who don't know each other. And they're asked to come together and make a big decision that might impact somebody's liberty or their pocketbook, and they have to make a big decision, and they really, really work at it. And they don't, the juries that I've had a chance to work with, I can say in 13 years, I've never seen them just rubber stamp it and send it through. They really, and they leave going, that was so hard. And we make friendships, we bond, we respect each other, but I don't want to do that again because it was so stressful and so hard. And in a criminal case, they have two choices. People think it's guilty or innocent, it's not. It's guilty or not guilty. And so what they do is they either say the state has proven its case beyond a reasonable doubt. It is this doubt that is this high that it's got to overcome. If I was even taller, it'd be that high. Okay, that's how high it is. It's not like could have done it, might have done it. It's got to be beyond a reasonable doubt. And the jury that comes back and says the state proved it beyond there, or they're not guilty, and that still might be, we think they probably are there. We think they probably might have done it, but you can still find them not guilty. So it really tilts in the favor of the state's got to show they got to get over that huge hurdle. And the juries I've had a chance to work with, I find that they really, really, really work at it. Now, I want to ask about the courthouses you go to, because we have some beautiful courthouses here in Georgia. 159 counties, we have a lot of counties. They all have a courthouse, and some of them are brand new. They look like our new Justice Center like we do in Fayette, but some have these old historic courthouses. Any courthouse that really sticks out in your mind that you've been to, visited, practiced, that you really, really like?
Actually, in the probate court in Newman,
Okay.
and the other one would be in Madison. Out front, it's just a beautiful old structure. I mean, and some of them, of course, haven't been renovated. I mean, I've been like some places, Fort Valley, I've been down to Fort Hill, and that's just basically a jailhouse and some rooms inside. But, most of the counties I found have come up with new justice centers. So some of the old courthouses, there's still one in Fort Valley.
Do they still have like the really big ceremonial courtroom that holds all the, like, some courtrooms used to have one courthouse, one big, huge courtroom that would have like seating for hundreds of people. But now we have a collection of small courtrooms.
Right, yeah. Well, that's one like that. I'm sure it's one in Madison that has the area, the huge area, especially, where the jury box and, prosecutors and counsel. It's just beautiful.
So in Fayette, anybody been to the brand new courthouse? 13 years. Okay. Now you know where the old historic courthouse is in the square. Now it hadn't been operational for a long time. In between, there was a courthouse annex. It's where the sheriff's office is now. So if you know if you had to get a police report where the sheriff is, that used to be the courthouse.
May I have your attention, please? The time is now 7:45 and the library.
On this, there you go. All right. Wrap it up. We're
If you
good.
have items you need to check
And I
out, please
remember
come
going
to
into
the
court
desk at
in
this
that
time to
annex.
do
And if you
so.
had two
We ask that all patrons
courts
stay
going on
in
at the
the
same
building
time.
before 8 p.m.
You
The
couldn't
library
park.
will be open tomorrow at 9
You could
a.m.
barely sit in there, and a judge would call a case, and it's standing room only. People were like, just sure. It spilled out the door. It spilled out to the hallway. It spilled almost out to the parking lot. And the judge would say, all right, State versus Bo McMichael. Is Bo McMichael here? And is Bo McMichael here? They go out to the lobby. Look for Bo McMichael. Go out to the parking lot. Anybody seen Bo McMichael? No Bo McMichael. Bo McMichael's not here. We haven't seen Bo McMichael. The judge say, all right, issue a warrant for Bo McMichael. Warrant for Bo McMichael. All right. I say Bo because Bo was my roommate in college. That was his son. So, all right. A judge may or may not have said that before about Bo. So, all right. So that's how it used to be. But now the courthouses have been designed a little bit better, but it's really cool. All right. Another question for you, John. 30 years you've been doing this. What's the biggest difference between practicing law then versus now, good or bad?
I think that before, in the past like 15 years ago, I'll say, there was better communication between the two sides. That, you know, you and the DA, I mean, you could fight like everything, you know, when you were actually going through the case, but from the standpoint of just, you know, trying to sit down and have civil conversation prior to and so forth, that used to be really good. Now, it's just a little different. It doesn't seem quite the same camaraderie. And I'd say that's probably it, but overall, from the standpoint of, you know, the justice system itself, I found it to be consistent. And that's one of the things what I like about visiting some of the older courthouses and some of the smaller towns, because it's one thing I practice and I believe in and I've seen it, you know, regardless. I was down in this little courthouse down in the courtroom, one with the jail and then the courtroom on the side. But my client walked away fair. I mean, just if they did, you know, in one of the metropolitan counties.
Do I have permission to send your contact information to everybody if they need to call you or anything? Can they do that?
Yes, and I got the card.
Okay, great. Any questions for John? Anybody have a question here? Big round of applause for John. I'm gonna take a picture with Chris and John real quick, but we're gonna beat the library bell. Did you enjoy it tonight? Yeah. All right. Did you learn something tonight? Give a big round of applause for these two guys. Great job. So, Grace, tell us what we have next week. We've got, you know what, something? All right. Sylvia, do you know something on the agenda next week?
There's an agenda.
Okay. It might be, Sue knows, because Sue is basically, teaching next class.
Fayette County State Court Judge Jason Thompson with another fantastic version of the People's Law School.
Zinni World, how are you doing? Jason Thompson here. Thank you for visiting us at the People's Law School. I hope you liked the video that Zinni took tonight. You're going to hear from Chris Puckett. He's going to talk to you about employment and labor law, and John Tate about trial preparation. Again, we bring the courthouse to the community, so thanks for checking us out, Zinni. Appreciate it.
Thank you. He's the man. See